Dear students, in the last classes we discussed about the concept of negligence. That means failure of duty of care. So you can file a case of tort for against the dependent for being negligent, for not doing his work, or for doing his work in a careless manner, or things like that. But there is a concept called as remoteness of damage. Remoteness of damage. This is a concept in negligence. Almost this will be almost an exception. So remoteness of damage, and in this case we will discuss about the very famous wagon mounts case. Wagon mounts case, right? So when we go to the details, let us discuss. So every person is liable for the tort committed by him. Tort is a simple offense which can be compensated with the damages. Maybe definitely it will be unliquidated damages. The court may award by using the personal discretion, right? So to award the damages, what are the necessary? Normally, so a person, the defendant is liable or for the consequences of the tort he has done. But to what extent? Damages, definitely they can a court can award damages. To a what extent? So not only the causation, that means not only the act of negligence, but the amount of compensation or the extent of compensation is also necessary. So to decide the damage, how far the damage was occurred, that to whether it is proximate, whether it is near, or whether it is remote. You may be knowing remote means very far from. So if the damage occurred is in the eye of a common man or in the thinking of common man is too remote, definitely you cannot ask the defendant to pay all the damages. So that is what is called remoteness of damage. So if the damage is too remote, if you did not expect that such damage will be caused, you cannot ask him to pay all the compensation. This is what is called remoteness of damage. So how this depends? It depends on the common man's perception. That means if a man thinks that yes, this could have been forethought or foreseen by the defendant, definitely he has to pay the entire compensation. No, if the person says or thinks that it is not possible for him to expect or to foresee that this damage would have been caused, then there will be some exception or lessening of the damages to him. This is what is called remoteness of damage. You may be daily you will be using remote to put on or to start your computer or to put on your TV. Why? Because it is a distant from your area. You cannot go to that place. So remoteness means that far away. Proximate means very near. Right? So as regards the damages, let us discuss. There is a very famous case called as Scott versus Shepherd. Scott versus Shepherd, which occurred in the year 1773. This is very famously called as the Squibb case. Squibb అంటే మట్టి మన నిప్పు ఇది ఉంటుంది కదా, నిప్పు బుడగలాగా చేస్తారు, అయితే కర్రకి నిప్పు కడతారు అలాంటిది. నార్మల్లీ వెన్ యూ లైట్ ఎ స్టిక్, నార్మల్ మ్యాచ్ స్క్విబ్ వస్తుంది కదా అది. సో హియర్ ఏ త్రూ ఏ స్క్విబ్ lighted match stick on B. What happens? B will do? B will definitely try to escape from it. So B has thrown that and squib and తీసుకుని he has thrown it on C. C has thrown it on D. Ultimately, it fell on E, whose eye was lost. It fell on the eyes of E. So who is responsible? So since the incident is one by one very proximate, definitely the damage, so A is held liable for causing the damage. It is what is called, it is not remote, here only it is a proximate. Therefore A is held liable. Actually, is there any connection between A and E? No. A through the squib on B, B in turn on C, C in turn on D. Ultimately it hit or caused legal injury to E. But still this man is held liable. This is what is called a remoteness of damage, because there is no remoteness, it is a proximate area. Therefore he is held liable. But how it can be decided? There are two theories, two tests. Number one test is test of directness. So if the damage is directly reflecting the action of the defendant, definitely he has to pay the compensation. Then test of reasonable foresight, here also the common. So if there is a common man of common ideology, if he thinks that, if he has got the foresight that this damage will be caused, then he has to pay that compensation. If he does not think, he need not pay the compensation. Right. So first point, let us discuss about the test of directness. There is a very famous case law called as Smith versus Southwestern Railway case co. Smith versus London Southwestern Railway co. It happened in the year 1941 or so. Right. Here what happened is, previously the railways were undertaken by some companies. So due to the negligence of the railway company, lot of heap of grass and hedges, అంటే కొట్టేసినటువంటి గింప అంతా రైల్వే ట్రాక్ పక్కన ఉంది. దే డిడ్ నాట్ టేక్ ఎనీ కేర్. దట్ మీన్స్ దే వర్ నెగ్లిజెన్స్. Ultimately, due to dry weather or due to the some our season is there, that is due to summer season, suddenly by mistake it caught fire. This heap of grass caught fire and it has extended to the house of the plaintiff, whose cottage was also burned. Incidentally, the cottage of the plaintiff is outside the railways arena. So who is held responsible? Definitely the railway is held responsible. Actually, the railways, they plead sovereign immunity. They said that our employees, the plaintiff could have taken care, he should have removed the heap. Why should the plaintiff remove the heap? It is the duty of the railway people to remove the heap or to put some water on it. But they left it like that because of their negligence. This thing happened. So since it is not too remote, definitely the reasonable foresight was not applied. The railways could have reasonably foreseen that by keeping the dry grass, some incident would happen. Since they failed, since they showed negligence, they were held liable. Right. Now we'll discuss very famous case. Please don't forget this case. This is called as Remoteness, Repolemis. Remoteness versus Furnace Wilthy Co. So that you need not remember. Remoteness, please remember. This is a best example for test of directness. So directly you are held liable. Here what happened is, Remoteness, this company, the appellant, he has taken a ship for hire. Or it is called chartered ship. Right. He got loaded benzene, tin and petrol also in the ship. He should have been more careful while loading the petrol. But somehow the petrol leaked and came onto the hold of the ship. Due to the negligent act of the servants, of the ship, the petrol which actually collected near the hold, somebody tried to immediately, it caught fire.